What does the Digital Markets Act mean in general, and how will it impact online marketing? One of the Digital Markets Act's key goals is to cultivate an ecosystem in which smaller companies can thrive and foster innovation, allowing them to compete with large tech platforms. Which companies does the Digital Markets Act apply to? These are the 6 gatekeepers to which the Digital Markets Act applies. It focuses on companies that own large online platforms and meet certain criteria, such as having an impact on digital markets, acting as an intermediary between companies and users, and having a lasting position of market power. How will it impact online marketing? One of the key points of the Digital Markets Act is that affected vendors such as Google will no longer be allowed to facilitate their platform services for the purpose of targeted advertising without first obtaining effective consent. This means that Google, for example, will have to prove throughout the entire customer journey that the user has also given their consent to, for example, dynamic remarketing. But Digital Markets Act also affects small businesses that use the gatekeeper services. It is vital for small business owners to understand the requirements of the Digital Markets Act and comply with the rules set by the gatekeepers as a result of this legislation. Advertisers need to understand how the Digital Markets Act affects them so that they can continue to effectively reach their target audiences while complying with data protection laws. What will be the implications of not being ready for the Digital Markets Act? Failure to comply with the Digital Markets Act is a very expensive risk for gatekeepers. However, for third parties, non-compliance is no less risky, as they would face loss of data, impact on audience management, conversion tracking, but also potentially loss of revenue and brand reputation. Worst case scenario? As Donna Dror, CEO of Usercentrics, said, the implication could be put quite boldly: no consent, no revenue. Looking at the whole issue, it might seem that this is just another regulation requiring companies operating in the EU and EEA to obtain explicit consent from users before processing their personal data. But this framework will mean a significant change for key players in ad tech, who will now be responsible for ensuring that the data they collect has proper user consent, whereas in the past, this was the responsibility of the websites using the gatekeeper services. What should companies do now? It is important to do your homework and assess your to-dos, and to work with partners who will keep you informed and guide you through these processes. When using Google services, it is important to first consider how consent is obtained. Google has provided a list of certified CMPs, including Usercentrics and Cookiebot, that can pass consent signals to the service provider. The second step is to evaluate whether you have enabled the basic consent mode, if you have not already done so. Step 3 is to migrate to Google Analytics 4 to maintain remarketing, audience and conversion export, and bid optimization. The time to act is now.